Yes, good morning.
Good morning.
Just to say two things before we start. First, we've read the papers, we've read some of the authorities, we've given judgment to some of the authorities. We have, I think, a lively appreciation of the issues, but that's not to say that we are necessarily on top of everything. But you'll take your own course. But that leads to the second point. Have you had a conversation about timing?
Yes, my lord, we have. My learned friend and I have agreed a timetable which should allow us to finish comfortably by lunchtime tomorrow.
Fine.
Whilst I've prepared how I'm going to develop orally the submission set of my skeleton argument, I am, of course, in the court's hands. And if the court would like me to focus on anything in particular, I'm very happy to be taken out of course. I want to make the most efficient use of the time available.
Well, I think what we'll do is let you take your own course, and we'll have questions as we go along.
Thank you, my lord. So, my lords, you'll have seen that I appear on behalf of the appellant Optima, and my learned friend, Mr. Zacaroli, leads Mr. Artley on behalf of the respondents. The court should have a core bundle, a supplementary bundle, and an authorities bundle.
Yeah.
So, the core issue in this case is whether it is unlawful to waive, clarify, or permit correction of clerical errors in a pricing schedule. Your lordships will be aware that Regulation 56 of the relevant legislation, the Public Contract Regulations 25, explicitly and specifically permits contracting authorities to request tenderers to submit, supplement, clarify, or complete information or documents which are or appear to be incomplete or erroneous, provided, of course, that such requests are compliant with transparency and equal treatment. Now, as the evidence showed, contracting authorities do commonly seek clarification or permit correction where there is an obvious error, including in pricing schedules. And we say that is rational and in the public interest, where it is compatible with equal treatment and transparency. Many high-value procurements set out detailed evaluation criteria, award criteria, relating to quality requirements as well as pricing. And unless they are procuring a contract for proofreading services, the contracting authority should be able to exercise their power to allow correction of an obvious an insignificant mistake in a tender, and I'll be coming on to how one determines those issues of obvious and insignificant. The effect of the judgment below, we say, is that common practice is unlawful, that for a contracting authority to permit correction or clarification of a pricing error in a tender is unlawful, except where the intended price can be deduced from the tender itself, or is otherwise known to the contracting authority. And this is so even if the error is an obvious error in one cell out of 1,000 cells, and even if waiving or correcting the error could have no effect whatsoever on the scores. Now, aspects of the judgment which go far beyond existing case law and have a real-world practical impact on tenderers and contracting authorities are first, correcting or clarifying an element of pricing is an impermissible change to a bid where the corrected price is not already apparent on the face of the tender. And secondly, permitting correction of a tender where there is a compliant tender breaches or risks breaching principles of equal treatment and transparency, not because of any possible impact on the scoring, but simply because it is unfair to a compliant tenderer. Now, if those propositions were right, it would create, we say, a striking situation of a straitjacket on contracting authorities, which is found nowhere in the legislation or the case law, and leads to perverse outcomes. If inadvertent errors in a pricing schedule cannot ever be waived, clarified or corrected, even if they've got no material impact on the scores, the outcome may well be, as here, the procurement turns not upon the award criteria, the evaluation of the quality or the pricing, but upon which tenderer can complete a lengthy document without a typographical error. Now, the courts have dealt with correction of errors on many occasions, but have never gone as far as the judge below. On the contrary, we have in the authorities bundle a relatively recent decision of Mrs. Justice O'Farrell, the Siemens case, which we'll be going to, in relation to the tender of a 2.75 billion contract, in which the contracting authority had sought clarifications and permitted corrections to the winning tenderer's bid during the course of the evaluation, including in respect of pricing. Mrs. Justice O'Farrell gave short shrift to the disappointed bidder's challenge on that point. She observed there was an obvious error in the tender and that the two changes to the pricing were not unlawful because in the first instance, the corrected price was not evaluated, and in the second instance, the corrected price was not substantial or material to the outcome. And the courts have said on many occasions the requirement for contracting authorities to observe the principles of transparency and equal treatment has the aim of promoting the development of healthy and effective competition. That's ARCUS at paragraph 25 as just one example. Promoting the development of healthy and effective competition. And we say that is the touchstone for the principles. It's not about applying rules formalistically or applying rules for the sake of applying rules. One has to look both at the purpose of the principles and also the broad logic of the rule being applied. And that's again from Arcus and Antwerps. Now, before I get into the reasons why we say the judge erred in reaching the conclusions that he did with respect, I'd like to emphasise by way of introduction certain features of the background against which this case arises. The background is set out fully in the judgment at paragraphs 5 to 69. I'm not proposing to go through all of it, but I would like to identify some particular features of relevance to the issues in this appeal. So the first feature, as your lordships will have seen, this case concerns a call-off contract under a framework agreement. Your lordships will have read that to be appointed to the framework agreement, Optima had to submit a spreadsheet of prices which would act as its maximum prices when bidding in any call-off contracts. They acted as a ceiling or a cap. And so that your lordships can understand what that means in practice, could we go to the supplementary bundle at tab 87?
Which volume is that?
Sorry.
I don't think it can be tab 80.
Sorry, it's not. It's page 87, so that will be
Volume 1.
tab 7. That's in file 1. So file 1, tab 7, and it starts at page 79. So this is the spreadsheet that Optima had to fill in order to be appointed to the framework. This is the encyclopedia of prices, as it were, which all act as its maximum. So in any call-off,
This is the framework.
Yes, this is the framework.
Right?
And could we have a look at page 87?
Yeah.
And we can look at one of the examples of where there was an error in the call-off. Page 87, on the left-hand side, you'll see OH58.
Yeah.
Yep, that's a hearing test.
Yeah.
And you can see there are 3 different rows, but OH58 is for an occupational health physician. And then you've got different orange and yellow columns. And if you go back onto the previous page 86, you can see those prices depend upon the mode of delivery. So one is telephone, one is face-to-face off-site, and one is face-to-face on-site.
Right.
So could I just make, under this first feature about the framework, I'd like to make 3 sub-points. The first is it was a contractual term of the framework agreement that the call-off prices were capped. And we can see that in the same bundle behind tab 2, page 29. So tab 2 should be Framework Schedule 3 framework prices. And on page 29, one can see clause 1.1.
Sorry, page 29.
Yes,
Yeah.
that should be clause 1.1. The framework prices will be used as the basis of the charges and are maximums that the supplier may charge under each call-off contract, and they cannot be increased except as in accordance with this schedule. Now, this term applied to the call-off, there is no dispute about that. Indeed, the respondents emphasised that repeatedly in their evidence. And could I ask your lordships to pick up Supplementary Bundle 2? And it's tab 17, the first witness statement of Mr. Samuel Birch.
Supplemental Bundle 2.
Yes, tab 17. This is the respondent's witness evidence, and it's the first witness statement of Mr. Samuel Birch, tab 17.
Yeah.
And I'd like to go to a couple of paragraphs. The first is paragraph 14 at the bottom of page 188. You can see that he was just emphasising that point. And then if we look at paragraph 15, he makes the point in relation to call-off contracts under the framework. And could I ask you just to note the last sentence of paragraph 15?
Yeah.
So again, emphasising this applied. And then the last point I want to take you to is on page 191. Again, being emphasised in paragraphs 24 and 25 as forming part of this ITT. So you can see paragraph 24 on page 199. He emphasises that under this ITT, it says the contract is being offered under the CCS framework, terms and conditions which will govern any resultant contract. 25, as noted in paragraph 14 above, the framework agreement itself made clear that maximum framework prices could not be exceeded. This was reflected in the pricing schedule instructions tab. As such, it was clear that any service line price in excess of the maximum framework prices would be non-compliant. So that brings me onto my second subpoint, as it were, about the framework. It was a fundamental requirement of this competition that the bidders agreed to those terms. And one can see that in the first supplementary bundle. I'll ask you to turn to tab 6, the first supplementary bundle.
Yeah.
This is page 78. You should see a document entitled Questionnaire 1.
Oh.
So this was part of the documents for this call-off contract issued by the DWP that Optima had to fill in, and this is Optima's response. Could I ask you to read the guidance at the top, which sets out a clear and explicit rule that if you did not agree to this, your tender would be deemed non-compliant and would be rejected. And could I then ask you to look at question 1.3, the question and Optima's answer?
Question
1.3. So you'll see there, Optima's being asked, does it agree without caveats or limitations that the call-off contract, if successful, would be governed by the terms and conditions of the framework? We've seen the respondents emphasising that one of those conditions is the framework prices are the maximum, that's the cap, and here we have Optima agreeing without any caveats or limitations to that. And similarly, if we go to tab 8 of the same bundle, this is the schedule which was actually completed in the call-off. And could I ask you to, your lordships, to go to page 108? I'm not going to read out the total offer price in case that's sensitive, but one can see that on page 108. And could I ask you to note, if successful, this is under the declaration. If successful, the organisation will be bound by the prices detailed in this pricing schedule, subject to the DWT call-off terms.
Yep.
That brings me to my third point in relation to the framework, the third and final point, which is that for a bidder like Optima to then include in its spreadsheet a cell in excess of the framework had no rational explanation, and that's paragraph 6 of the decision. Which is core bundle 5, page 48.
Page?
48. Core bundle, tab 5. And indeed here, it was obvious, in line with that, that the cells containing higher prices were errors, and could I ask you to go briefly to file 2 of the supplementary bundle.
Just before we do that, where am I on page 48? Which part did you...
Paragraph 6, the last sentence.
Well, it's accepted, isn't it? It was an error.
Exactly. Of course, it'd be an extraordinary and irrational act of self-sabotage to put in a cell. Why bother going through it all? Particularly in circumstances where you have committed unequivocally to the cap. But if we just see that in practice, or what happened in practice, if we go to file 2 of the supplementary bundle, this is tab 31, page 262 of the supplementary bundle. And this is supplementary bundle 2, tab 31, page 262. And this was the checking of the pricing schedules. Could I ask you to have a look at the bottom, which is...
So when you say the second of the pricing schedules...
No, sorry, I didn't mean to say. This was the checking of the pricing schedules. This was
checking?
Yes, sorry. This was DWP checking the final version of the pricing schedules.
Yeah.
And could I ask you to read paragraph 4? You can see Optima prices are much higher for those 3 cells, are much higher than the framework price. The OH58 overprice cannot be explained or require query. There is no volume against OH55. Now, it's the point I'm going to come on to, and it's a very important point, because I'm not sure it comes out clearly from the judgment. That price was not evaluated. It did not form part of the evaluated price. Where there was a 0 volume, it did not contribute to the scoring or the evaluation at all. I'm not sure that comes out clearly, but I'll come on to show you that is not contested. It was admitted in the defence. And it was an important point below.
Okay, so 229 and 230, this paragraph 4 is the root of the point made in another document that it's a cut and paste error.
Exactly, because 229 and 230, you can see the requirement was for an occupational health advisor or a specialist advisor. you can see in the box at the bottom of 262, the first column is the maximum price in the framework, 105 and 208. What the supplier had bid was 165 and 560. If you turn over the page, they literally explain how that's arisen. Because you can see what they've used, what Optima inputted by accident, was the different mode of delivery. They should have been putting in the telephone maximum, which you can see was 1 or whatever they wanted to, but the maximum for the telephone was 105 and 208.50. They put in face-to-face 165 and 560.
So face-to-face rather than telephone.
Exactly. So the mode of delivery was mistaken. And that was perfectly clear on the face of the document when it was first checked.
But whether it gets there by a cut and paste or whether it gets there by any other reason,
We said completely relevant.
Well, just obviously,
Yeah, sorry.
that in a way, that's not. I mean, I know the evaluation because there's a document at 265 where they try to work out how it can have happened or why it's happened. But the bottom line is, it's got a number in it which is in excess of the number in the framework.
Yes.
I mean, that's.
Yes, but we're going to come on to whether it's an obvious error, and you'll have seen my ground ground two is the judge's approach to obvious error, which we say is wrong. So we say it was obviously an error, and in the case of OH225 and OH230, the cause of the error was also pretty obvious. It's been put down here. The wrong mode of delivery was used.
Yeah. And you'll come back to OH58.
Yes, I'll come back to OH58.
Okay.
There, basically the price, the CCS price, the framework price, 40, was a mistake.
Yeah.
But the important point to note is that only one of these, and that's the middle one, OH229, had volumes against it, so was evaluated. The other two had 0. So that brings me on to the second feature of this case, which is the lack of materiality. The errors in this case had no impact on the score. It is undisputed that Optima would have been the highest scoring bidder, and that's paragraph 61 of the judgment.
Mm-hmm.
And in relation to the 0 volumes, could I ask your lordships to go to the core bundle and the amended defence, which is tab 9, page 150. And it's paragraph 48. This is the defence. Paragraph 48, you'll see, as to paragraph 60, it's admitted that 2 of the errors did not affect the pricing evaluation as they had volumes of 0. But one of the errors directly affected the pricing evaluation. We'll come on to see what that actually means in practice. Couldn't have affected the outcome. What that means, must mean, and can only mean, is that one of the errors was evaluated, one of the prices in which there was an error was evaluated. And then they said, further, the 2 errors which did not affect the pricing evaluation were still significant, as the authority must have accurate pricing in order to use a service line, where that effectively forms part of the contract, i.e. they would have had to know the price for the contract.
And just for my note against that, which one is it that did affect the pricing evaluation? Evaluation OH 229.
I think.
I'm grateful, yes.
Thank you. Yeah.
And you'll have seen a difference in that price. The reason that the impact of that price was it was over the framework by £60.
Yeah.
And the volume, the indicative volume, was 10
Yeah.
of those. That's where you get the £600 per year. And you will recall the overall contract value into the millions.
Yeah, so it's £600, which is the source of the 0.02%.
Exactly.
Yeah. So that's the effect on the price evaluation.
Exactly. And on that, whilst we're here, could we just go to Supplementary Bundle 2? tab 34. Page 269. And this is an exercise that the respondents undertook on page 270. One looks at little Roman 3.
Yeah.
They applied the cap. They applied the cap for other purposes, and you can see, as they said, this had minimal impact on pricing, with Optima adjusted down 0.02% and Health Partners minus 1.59%.
When I was pre-reading this document, what's the date of this document, 269, 270?
I don't know that offhand, my lord.
Okay, well, if somebody could
check, yes, that
find out and let me know.
Yes,
Thank you.
Now, whilst I'm here, I'm just going to deal with one point on volumes, one final point on volumes. This is supplementary file 1, tab 8, page 105. And this is the call-off schedule with its instructions. Could I ask your lordships to read on page 105, instruction 1.1 at the top, the very first note, 1.1. So these aren't figures plucked from the air, they're based on actual figures from the previous 3 years, which means that where there was 0, those services had not been required at all in the previous 3 years, and where there is 10, that was the yearly average from the first 3 years. They are selected in order to provide a basis for financial comparison and evaluation.
Yeah.
Now, of course, that might mean in 1 year you need 12 or you need 6 rather than 10. They're not guaranteeing anything. But if I could show you the difference between 10 and other services, could you look, your lordships, look at page 107 and OH1, and the indicative volume there was 95,000. That's page 107 OH1 for a different item. The indicative volume was 95,000.
Yeah.
And we'll come on to this because it's said against me in terms of materiality. Oh well, it was only £600, but it could have been more.
Yeah.
And there's an air of unreality about that. It's certainly not going to suddenly jump to 95,000. Now, the third feature of this case is important for putting the errors in their proper context, because, of course, it's very easy, if not involved in this, to think, how difficult is it to submit a spreadsheet correctly? How difficult is it really? And that's where we risk looking at this out of context, because what the evidence showed is that there were genuine difficulties in doing this. And one can see that in the judgment
Just before we get
itself.
on
Yes.
to that, but as part of that issue, how many line items were there? Not the data point, but just the line items that are being filled out.
I will ask those behind me to confirm.
A couple of different numbers. I think 133 is a number that I've seen, but I think there might be other ones too. So it's how many line items the bidders had to fill out for this call-off contract.
I will ask
So
those
it's
behind
3
me.
out of question.
Yes, although of course when you say line item, do you also mean the different modes of delivery? Because for a one line item, there might be 3 modes of delivery, and they might be asked to put in a price for each of those, or only one of those, or 2 of those. That's why we've talked about cells.
All right. Well, that's a cell, is it? That's what's meant by cell. Okay. Well, the 2 numbers then.
Thank you.
As long as it's clear that what I mean by cell is where there are different modes of delivery for a particular service line.
Which they had to fill in for the call-off.
Say again?
Which they had to fill in.
Which they had to fill in
for the call-off.
Yeah.
Thank you. I'm sure that those behind me are busy doing that now. So, the third feature of this case, just to put these errors in context.
Well, that would for me put the errors in context, knowing those 2 numbers.
Thank you. We'll do that. In addition to those, could I ask you, Your Lordships, to consider a few other points to put these in context? The first is that, as recorded in the judgment, and if we go to that judgment, it's core bundle, tab 5. The spreadsheet was repeatedly reissued and repeatedly filled in with errors by all tenderers. And we can see that first in paragraph 23. So that's the first time, that's the March 22 schedule. And could I ask you to note, none of the bidders returned a fully completed pricing schedule. Then if we go to tab 25, we can see there was then issued a second pricing schedule, paragraph 25. An internal review revealed there were problems with the procurement and the evaluation of the quality submissions was reconducted. The second pricing schedule remained non-compliant. Certain service line items exceeded the framework prices, and Optima's prices contained a number of qualifications. All other bidders' pricing schedules were also subsequently discovered to be non-compliant. But the bidders weren't being told the precise nature of what they'd missed or where they'd gone wrong. So it's a bit like being handed back a long document saying there's a problem in there, but not being told what it was. And there are any number of potential problems, not just framework maximum prices. So 25, second time round.
It says in 23, though, that DWP attached a copy of the pricing template with certain cells highlighted yellow, which bidders were asked to ensure they'd completed. So one assumes that means drawing attention to cells that hadn't been filled in.
No, because that wasn't individualised. My understanding is that was, if one reads then, Your Lordship, if you could read the extract below, that's the email which was sent. My understanding is they were sent rather than individualised, you missed this price. All prices which had to be filled in were yellow. See, all parties will now need to complete the attached pricing template in full. All yellow sections must be completed.
Yeah.
Yeah, so it wasn't company A, you missed cell 32.
I don't think we're disagreeing. I'm just it's
Thank
highlighting the things that the information that has to be inputted.
Yes.
Hadn't been.
Exactly. And similarly, and it's a point made against me, they were told repeatedly you mustn't exceed the framework prices. But that's a bit like being told you mustn't make a typographical error. If you're not actually pointed out where you've gone wrong, you might miss it again. So we've now had first pricing schedule, everyone got it wrong. Paragraph 25, second, everyone got it wrong. Then could we go to paragraph 30, third pricing schedule. Everyone's schedules are non-compliant.
It might be suggested there are better ways of procuring public contracts than this. I think anybody not familiar with procurement might look at this case and think, is this really the best we can do in the 21st century?
We entirely agree. People are stumbling around in the dark with repeated pricing schedules being submitted where we know that other contracting authorities simply clarify. They say in cell 561 you've said X, did you mean X? Because it's in excess of the framework. It's a much more efficient and we say entirely compliant way of dealing with this. So the last paragraph I wanted to go to there was paragraph 53. And this is the final round. And effectively, there's one man left standing. Of the 4 bidders, 1 had withdrawn in March 23 following its acquisition. Another had been excluded on qualitative grounds. A third had also submitted price in excess of its framework. and therefore Pam was the only compliant bid.
Yeah.
As of the 4 other bidders.
Those are the 4 apart from Optima. Yes, so
Yeah,
5.
so
Yeah.
there's 5.
Yeah. Now, whilst staying on this third feature about putting the errors in context, could I also ask you to note that DWP knew that the risk of inadvertent error was high, and we see that from the decision at paragraph 31. And could I just ask your lordships to read paragraph 31 and the extract yourselves?
Yeah.
And the third and final point on this third feature is that the DWP's own rigorous and robust checking system didn't pick up all the discrepancies. And we can see that if we go to supplementary bundle number 2, and we go to the first witness statement of William McPherson at tab 18. So this is the evidence of DWP that they put in below.
Age.
Witness statement of Mr. McPherson. And if we go to paragraph 52 on page 30 on page 212. I could ask your lordships to read the first half of that down to the sentence ending Cheryl Brown.
Mm-hmm.
Then could I ask you, so they were quadruple checked. And then if we go over the page to paragraph 36, could I ask you just your lordships to 36? Now, at the same time, the witness statements in the first round were exchanged simultaneously. And just as that witness statement was submitted, Optima put in its own witness statement from Joanne Newey, in which she made an important point at page 180 behind tab 16. I could ask your lordships to read page 180 behind tab 16, paragraph 136 to yourself.
Right.
And in a responsive witness statement, we can see how the DWP addressed that, and that's behind tab 19. It's the second witness statement of Mr. McPherson.
This is the 4th cell, isn't it? Is this the
Exactly,
4th?
fourth. Hadn't been picked up by Optimus checks or the quadruple checking by the DWP. We see that behind tab 19, page 232. I could ask you to read to yourselves, your lordships, paragraph 49 on page 232.
Yeah.
Now, of course, our submission is it demonstrates rather more than just that there were 4 errors in Optima's bid. It demonstrates that despite quadruple checking by DWP and Optima's own checking, there was nevertheless a discrepancy which wasn't picked up, and that illustrates in real life how difficult this was. That moves on to the 4th feature, which is the evidence that other contracting authorities clarify. And this is, we can remain in the 2nd supplementary bundle. We go back to the witness evidence of Miss Newey behind tab 16. Could I ask your lordships to have a look at page 164 and read to yourselves paragraphs 33 to 35.
33 to 35.
Yes,
Yeah.
on page 164.
Yeah. You refer to that in your skeleton. I marked that up.
And there are just 2 other paragraphs that I'd like to draw your lordship's attention to. One was paragraph 44 on the next
Just
page.
before we leave 33 to 35, I understand that point, I understand that evidence. In one sense, the rather better point is that in the cases about pricing, the authorities about pricing, the most recent 2, Siemens and Antwerps, are cases in which the challenger challenged the contracting authority's decision to seek clarification. This is just on pricing points.
Yes.
Because it's one of the reasons I gave permission to appeal. The only authority on pricing where the complaint is by the contractor who made the error is ADIA,
Yes.
and that's 30 years old.
Yes. Yes, madam.
So whilst I understand 33 to 35, it could be said that that evidence is borne out by the fact that the 2 most recent cases on changes to figures are challenges to a decision by the contracting authority to seek clarification.
Yes.
All right, you're going to show us another paragraph?
Just 2 more. One was paragraph 44 on the next page.
Yeah.
And the final one was on page 178, paragraph 126.
Yeah.
So that brings me on to the 5th feature, which is the procurement documentation. So in addition to the disputed clause, which I'm going to be looking at in some detail in my ground 1, I wanted to highlight some additional features to put that in context. So could we go to the core bundle, tab 10. These are the terms of this procurement.
So is tab 10 the ITT?
Yes. We can see from page 160 what the ITT consisted of.
Yeah.
So just so that when I come onto my ground 1, we can see the landscape within which the clause sits. Could we look at page 161? And under clause 2.2, we have the phrase beginning the maximum contract value, which we're going to be looking at in some detail. I'm not sure why it's highlighted. I don't think there's any significance attached to that. But could I ask you, rather than focusing on that now, because I'll make my submissions on that, could we have a look at a few other clauses? The first is 2.4, which is the point emphasised in the DWP evidence that the terms and conditions would govern any resultant contract. So as a matter of contract, to which Optima had agreed, the maximum prices under the framework were the maximum prices. Over the page, if we then go to page 166, and it's section 6.9 R rights.
Mm-hmm.
So one can see here, 6.9.1, we reserve the right to waive or change the requirements of this bid pack from time to time without notice. Second bullet point, and I don't believe actually that first bullet point is recorded in the decision, but it's obviously uncontroversial, and we also do rely on it insofar as necessary, the express power to waive the requirements. Second bullet point, verify information, seek clarification, or require evidence or further information about your bid. And then if one goes to 6.9.2, exclude you, this is a right, if you submit a non-compliant bid. Non-compliant, not defined. Now we have some very clear examples of where bidders are told where their bid will be deemed non-compliant and will be disqualified. One is on page 173. And I've already taken you to Optima's completed version of this. So you'll have seen the guidance under 2.4, which says, if potential providers are unwilling or unable to answer yes, their submission will be deemed non-compliant and shall be rejected. Over the page 174.
Sorry, so this is now so this is attachment 2. Just the number of different documents that make up the ITT.
Yes.
So attachment 1 about the procurement, attachment 2 how to bid.
Yes.
And then this is the
key participation requirements.
173 is the bit you've shown us in the bid that was completed.
Yes.
Yeah.
So this is question mark, key participation requirements, made clear that if you don't agree to these, your submission will be deemed non-compliant and shall be rejected. Over the page 174, same in relation to conflicts of interest, questionnaire 2.
Yeah.
And that's at the last sentence of the guidance under questionnaire 2. If potential providers cannot or are unwilling to suitably demonstrate they have suitable safeguards to mitigate any risk, their tender will be deemed non-compliant and will be rejected.
Mm-hmm.
Page 176, there's another example of a requirement at page 2.13, sorry, clause 2.13 on page 176. Page limit of 30 pages. Anything in excess of that cap is disregarded. Now on the same page you can see, your lordships can see the award criteria. So the first, questionnaire 4 quality, your lordships can see to the right hand of that box weighting was 70%. So it's heavily weighted towards quality, in which, as I think the decision records, Optima was scored significantly higher than the next place bidder. And then if one scrolls through all of those, one can see many quality questions. One then comes to, on page 184, price, which had a weighting of 30%. Those are the award criteria.
Yeah.
Now, the sixth feature is not so much background as context. Your lordships might well be wondering why Optima is pursuing this. Because Optima wanted the contract. DWP held off awarding the contract, pending the decision below. DWP didn't enter into the contract, it wanted to wait to see what the judge said. It has now entered into the contract.
Yeah.
Now, could I make 2 points in relation to this? From Optima's perspective, the ruling on the grounds is of real practical significance for 2 reasons. One is its wider repercussions, because they've seen the evidence from Mrs. Newey about how it is commonplace under frameworks for Optima to be putting in spreadsheets, and there has previously been a practice of clarification. That is important in its own right. The second is that this claim was actually a set of preliminary issues and a wider set of proceedings, and your lordships may have seen that part of what else was challenged was that the winning bidder, Pam, the incumbent, has also been awarded a series of unlawful direct awards, which DWP has admitted are unlawful. Those awards continued after the commencement of these proceedings, and in relation to that complaint, where damages are sought, it is likely that any entitlement to damages and the period for which damages could be available could well entail arguments about the merits of these proceedings and the period during which these proceedings were brought.
Just help me with that link. I'm not following that. So there's separate proceedings that or separate claims as part of these proceedings.
Part of these proceedings.
Part of these proceedings, but separate. And that's a damages claim.
That's a damages claim. And both before and after this claim was brought, those awards were made to Pam the incumbent. They've been challenged over a period of several months, if not years. But they run up, of course, right up until the point at which this contract was awarded after the judgment.
Right.
Now, one can see if DWP say that Optima brought these proceedings incorrectly on a false basis, had nothing to complain about, then they shouldn't be entitled to any damages, even if that award was unlawful post the claim, because that award wouldn't have been needed, because it was only Optima choosing to bring misconceived proceedings, which led to that direct award being in place in any event. I'm not sure I've explained that succinctly.
No, I'm struggling to follow you, but just before you try again.
Yes.
By unlawful direct awards, do you mean under the same framework
Yes.
agreement? Right. Okay. So there are other call-offs within the same framework that have been done without competition by direct award to PAM.
Yes. And the DWP have admitted those are unlawful, but there's a question about causation.
I understand.
I was going to say it's causation. So you'd say, so DWP could say, well, the unlawful direct awards had no impact because in the end we had a lawful contract with DWP.
And we should have been able to enter into it last August.
I understand.
Yes. So none of that needs to concern your lordships, of course, today.
Hang on, just before you go on, let me just make a note of that.
Did you say that was background or context?
Context.
That's context.
Yeah, okay, well, I understand that.
So
Background, context, jury, we understand.
I have now completed my section on the features of the case. I was going to now, before coming to the specific errors, make a few submissions on the case law principles. Now here I'm very much in your lordship's hands. If I take you to paragraphs that you already know back to the front and by heart, then please tell me and I will rapidly move on. But what I hope to do was just touch on a few points under 3 topics on case law principles. Mm-hmm. And because the grounds of appeal are intertwined, I'm going to deal with all of these and then come on to the grounds of appeal. So the first topic is the strict need for clarity of rules imposed by a contracting authority. And your lordships will have seen the case law that if a contracting authority is going to exclude a tenderer for failure to meet a requirement, they need to make that consequence very clear indeed. And it is, of course, important to distinguish between the clarity of the rule and the clarity of the consequences. Because, of course, one could be told repeatedly that you've got a 30-page limit, could be told that repeatedly, but if you're not told what the consequences are and you're then disqualified, that raises different issues.
Yep.
So the two cases that I was going to go to rather quickly, but just highlight a few features, were Healthcare at Home and Clinton.
Yep. Healthcare at Home
is in the authorities bundle, the first authorities bundle. Tab 16. That's page 285 if you're using the electronic bundle.
Yeah.
Now, I'm sure your lordships are familiar with the introduction, the Clapham Omnibus, and in paragraph 5, the description of the R-wind tenderer, the construct.
Yeah.
Could I ask you to note over the page on 288, or internal numbering 250, the Supreme Court referring to the 46th recital of the Procurement Directive, in that first paragraph, contracts should be awarded on the basis of objective criteria which ensure compliance with principles of transparency, non-discrimination and equal treatment, and which guarantee that tenders are assessed in conditions of effective competition.
I'm sorry, I've completely lost where you are.
Sorry, page 288,
Yeah, I got
behind
the
tab
page.
16, and it's the indent at the top, that's citing the 46th recital.
Oh, at the end of paragraph 5.
Yes. Because we're coming on to this touchstone of the application scope of these principles and what they require. So you can see it's effective competition. If one then comes down to paragraph 8, we can see the key principle. The award criteria must be formulated in such a way as to allow all R-wine tenderers to interpret them in the same way. And if one can see at the bottom line of paragraph 8, they need to be sufficiently clear to permit of uniform interpretation. Now, it's not just, although that paragraph refers to award criteria, it's not just award criteria. And we can see that from paragraph 13 on page 289. Paragraph 56 over the page, citing from EVN, it says the procedure for that paragraph 56, the indent at the top of page 290, the procedure for awarding a public contract must comply at every stage. And then if we go down to paragraph 15, it's made explicit. Could I ask your lordships to read indented paragraph 109, which is being a citation from Commissioner Netherlands. So that's not just award criteria, it's all the conditions and detailed rules. And the phraseology is clear, precise, and unequivocal. Could I ask you also to note that tenderers need to understand their exact significance. So it's not just interpreting them in the same way, it is being able to understand the significance of the conditions and the detailed rules. And the final point in Healthcare at Home is on page 297 and paragraph 27, which is the key paragraph about this being an objective determination, but it's not the same as contractual interpretation.
Page 297, you said.
293, paragraph 27. Apologies, paragraph 27 on page 293.
Yeah.
And the second case I wanted to go to was William Clinton. We'll go briefly to the first instance and then go to the Court of Appeal. And the first instance is behind tab 14, page 217 in the same volume. And could I ask your Lordships to turn to page 223, and just above that quote at the bottom, page 223, one can see, having regard to the terms of the impugned decision and the reasons thereof proffered by the Department, the spotlight is firmly on selection criterion number 1, which was formulated in the following terms. And could I ask your Lordships to read that formulation?
I'm afraid yet again I lost where you were.
Sorry.
Going. Right. I'm on 223.
That one can see at the bottom of that page an indent starting tenderers must demonstrate.
Yeah.
That's the selection criterion which was said to have been formulated with inadequate precision. And the focus is going to be on the word outcomes. Now, just so one can see the contours of the dispute, this is on page 224. Paragraph 9, the complaining tenderer was told, well, you didn't provide sufficient evidence. And at the bottom of page 224, you can see their complaint, well, it doesn't ask for evidence. It talks about outcomes, and we explain the outcomes. And if we go to page 226, paragraph 12, here's the focus of the dispute, 12 little Roman 2.
Entirely sure why you're showing us this.
Oh, it says to put, because it's just so that one can see, rather than seeing the abstract, the principles, one can see the context. But if your Lordship doesn't need this...
No, I'm not talking for my brother judges at all, but the first instance, Clinton, outcomes and evidence, I'm not sure where that gets.
Okay, it's just that when one's talking about... I find it personally helpful when looking at being told the phraseology was ambiguous, rather than that just being an abstract notion, when one can see it in the factual context in which that was decided. But of course, I'm very happy to move on more quickly.
So, first instance, the judge found that selection criteria fail the test of sufficient clarity.
Yes.
And I think subsequently said that it was not unclear or something or other else, but along the same lines. Yeah.
Yes.
That's it. Unacceptable degree of doubt and uncertainty.
Exactly.
Yeah.
It's page 252, paragraph 40.
Yeah.
And yes, phrase that we particularly rely on is it's expressed with insufficient clarity. And over the page, 252, the phraseology of, this is where the lining is, the phraseology of this criterion, in my view, gave rise to an unacceptable degree of doubt and uncertainty.
Yeah.
And then that was upheld in the Court of Appeal by a majority, and that's in the next tab, tab 15. And the 2 points that I just wanted to draw to your attention quickly, because I appreciate that your lordships have this well in mind, is page 267, paragraph 35. The point being made, if you're going to exclude someone on the basis of a requirement, you've got to make that requirement very clear indeed. That's 35. It was a criterion of fundamental importance because if not satisfied, the result was the exclusion of the tenderer from further consideration, no matter how good the rest of his tender had been. Such a criterion, a breach of which was fatal at the outset of the whole tender, was one in respect of which the principles of clarity, fairness and equality of treatment demanded particular clarity and transparency. And of course we say that's the same in this case because of the impact of the apparently mandatory rule. You make an error and it can't be clarified or corrected, you're out. So I'm not sure your lordships need to look at anything else on that first topic. The second topic of principles is correction and clarifications of errors. And we say that tab 7, the Arcus case, sets out comprehensively the restrictions which apply to the discretion to seek clarification and corrections, permit corrections. And if we pick this up on page 105, I'm just going to highlight a few points. Now this is the case where the tenderers put in the wrong sample. They attached the wrong sample. They had to attach a sample to their tender and they put in the wrong one. And paragraph 25, the court starts by recalling the point I've made about the touchstone, which is that the requirement for the contracting authority to observe the principles of equal treatment of tenderers has the aim of promoting the development of healthy and effective competition. And 26, that requires equality of opportunity when formulating their tenders. 27, we obviously can't have negotiation. 28, to enable the contractual authority to require a tenderer whose tender it regards as imprecise or failing to meet the technical requirements of the tender specs to provide clarification would run the risk of making the contracting authority appear to have negotiated with the tenderer on a confidential basis in the event that that tenderer was finally successful to the detriment of the other tenderers. And of course, one can see that specifically in relation to award criteria such as quality criteria, where someone appears really not to be up to scratch, but you invite them to provide further details. But 29, however, the court has also previously heard that the principle of equal treatment does not preclude the correction or amplification of details of a tender, where it is clear they require clarification, or where it's a question of the correction of obvious clerical errors, subject, however, to the fulfilment of certain requirements. And here we have the requirements. 30. First of all, it can't be made until the contracting authorities looked at all the tenders, must be sent out in an equivalent manner. 31. It can't lead to the submission of what would in reality appear to be a new tender. Now, the court doesn't define new tender. There is no bright line, and we can see here it sends us back to the National Court to decide whether there was a new tender.
Well, because that depends what the clarification includes, doesn't it?
Sorry, my lord.
But that will depend on what the clarification
Absolutely.
includes.
It's a matter of fact and degree.
Yeah.
32. Lastly, as a general rule, when exercising its discretion as regards the right to ask a tenderer to clarify its tender, the contracting authority must treat tenderers equally and fairly, in such a way that a request for clarification does not appear unduly to have favoured or disadvantaged the tenderer or tenderers to which the request was addressed, once the procedure for selection of the tenders has been completed, and in the light of its outcome. And we say there, that shows the court is not applying this formalistically. It's not saying on the one hand you have a compliant tender, on the other hand you haven't. That in itself is discriminatory. We've got a set of conditions here, and one of them is, does it appear to have unduly disadvantaged the tenderer once you have it in light of the outcome? It allows a real-world test of the materiality of this. Then 33, a request for clarification that cannot, however, make up for the lack of a document or information whose production was required, the contracting authority being required to comply strictly with the criteria which has laid itself down. Then it refers to Manova, paragraph 40. Now, Manova's not in the bundle, and that deals with provision of documents. What Manova says in paragraph 40 is you can't permit a document where you said you have to provide it by deadline on pain of exclusion. Then if we go over to finish up on this case, over the page, paragraph 36, I'd ask you to note in paragraph 6 the formulation that the court uses. It says, a request sent by the contracting authority to a tenderer to supply the declarations documents required cannot in principle have any other aim than the clarification of the tender or the correction of an obvious error vitiating the tender. So it can be an error which vitiates the tender, but that can still be corrected. It cannot therefore permit a tenderer generally to supply declarations of documents which were required to be sent in accordance with the tender spec and which were not sent within the time limit for the tenderers to be submitted. And then again it makes this point about what constitutes in reality a new tender. Then paragraph 37, it says the obligation which a contracting authority may have under national law to invite tenderers to submit declarations of documents required which they have not sent within the time limit, or to correct those declarations of documents, cannot be permitted except insofar as the additions or corrections made to the initial tender do not result in a substantial amendment of the tender. It is apparent from SAG that the initial tender cannot be amended to correct obvious clerical errors other than exceptionally, and where that amendment does not result in reality in the proposal of a new tender. And then 38, it's for the referring court to determine, and then paragraph 39, we have those conditions encapsulated. So that is the extent, that is, we say, the extent of the conditions which allow flexibility. It's not about a change to a tender. There's nothing saying that you can't make a correction where you are saving what would otherwise be a vitiated tender, quite the opposite. And it's not saying there are any categories such as price that you just cannot touch. Now, I'd like to highlight now just a couple of points in time. Yes, my lord.
I mean, this was a case about microfilms. And like a lot of these cases, a case about something that wasn't provided or something erroneously provided or not provided at the right time. From which one gets some assistance in this case, but not, in my view, a huge amount of assistance. And like so many of these European cases, there's an awful lot of principle and not much application of that to any facts. 2 points. Paragraph 36 talks about correction of an obvious error vitiating the tender. It wasn't clear to me where that came from. And similarly, in paragraph 37, when it talks about a substantial amendment of that tender, it's not clear where that comes from. I mean, I understand the general principles, but those 2 points I slightly stubbed my toe on in terms of referring to cases, but actually I don't think SAG, for instance, says either of those things.
No, and we would say that what the court has done rather cleverly here has set out quite high-level conditions which have sufficient flex in them to meet a wide array of circumstances. And what is significant can obviously be a matter of fact and degree. What's a new tender can be a matter of fact and degree. We rely, I entirely agree, my lord, obvious error vitiating the tender, I can't see where that comes from. But what we can see here clearly, because that is at the statement of principle, that even where you have an obvious tender which would otherwise vitiate the tender, that can be corrected.
Yeah.
And it can, clarifying or correcting error can turn a non-conforming bid into a conforming bid. We see that in Thailand, we see that in Antwerp. We see that confirmed here.
Yeah, not a new tender, or in effect a new tender. That comes from Antwerp.
Yes. So, if your lordships will indulge me for 5 minutes, I'd like to go to a few aspects of Thailand and Antwerp. I understand that your lordships...
You'd like to go to...
Thailand and Antwerp, just to pick out a few.
Yeah. Thailand is... They didn't do it in time.
No, Thailand is where they had the tender had to be valid for a certain period.
Oh yeah, the date.
The date. So they said, on the one hand, yes,
because
it's valid.
the thing was extended, but the date stayed the same, so therefore the date expired before the 90 days.
There was an obvious ambiguity.
Yeah.
And my lordship, you'll have seen...
If I couldn't have answered that case correctly, I'm bound to say I think I'd have thrown away my wig. And so I always think that it's a bit sad that Thailand is really an authority for anything. But
yes, although we would say, you can see why we say that applies here, where you've got on the one hand Optima saying, unequivocally, without caveats or qualifications, we sign up to these contractual terms, which include, as the DWP emphasises, maximum framework prices. And then on the other hand, you have a couple of 3, as it turns out, 4 cells which exceed them. And we say that, therefore, does bear an analogy to Thailand.
okay, well, do take us to those, because they're both relevant, because this is all under your heading of correction and clarification of errors.
Yes.
So Thailand, tab...
4.
4, thank you. Yeah. Yeah.
And so, starts on page 57, which explains the point about the period of validity, and paragraph 4 is where we get the reasons for rejecting the tender, because it said it was valid for 90 days, but then it said by a certain date, which wasn't 90 days from now. And what I would like to highlight is a few arguments of the parties, because the Commission pushed back very strongly here, and we can see some of the arguments that it raised really being relevant to these proceedings. So the applicant...
Well, lots of these earlier cases are the contracting authority was the Commission.
Yes, exactly. So paragraph 20, you can see that the applicant says, well, look, this should have, at the very least, have led the evaluation committee to exercise its powers to seek clarification. And over the page, paragraph 23, the Commission, first of all, says, well, there's no ambiguity, there's no uncertainty. You've given a date, and it's not 90 days from when it was required to be valid. And then it says, with regard to the applicant's argument, there may have been a certain suspicion as to the correctness of the date. It's an open question whether a suspicion has arisen in a particular case, such as would oblige the Commission to accept a date unambiguously put forward. Then if we go down to paragraph 25, they rely on the fact that this is an error, which can't be corrected. Paragraph 26, they rely on the fact that it is the applicant's own fault. That's the last sentence of paragraph 26. It's an error which the applicant itself now claims to have made, which caused the applicant's tender to be rejected. There is no suggestion in that case, by the way, that the error was unavoidable, or that there was any, it was as a result of anything supervening. It was just an error, a slip on the part of the applicant. Then here, paragraph 27, they emphasise the importance, the Commission's emphasising the importance of the detailed and precise conditions of a tender procedure. the ongoing and strict respect of which represents a sine qua non for admission to any tender, by analogy in particular with the position of respect of competition. And this is the Commission arguing, economic operators will be fully aware of those conditions. The tender submitted in respect to the very same project by the applicant had previously been rejected in 2001, and the applicant should therefore have been especially vigilant when it submitted its tender on this occasion. In particular, it should not have simply resubmitted the same documents without even checking the dates. So here we have, it's all your fault. And we can come on to see that the European Court didn't say, well, no, it wasn't the fault. It effectively accepts it must have been the fault. There's no suggestion there was some special circumstance. But that doesn't stop the obligation arising. Then here, paragraph 28, I ask you to note, the Commission argued that the dated issue regarding the extent of validity of the offer is of fundamental importance, not only for the contracting authority, but for each of the individual tenders. The former must know with certainty when each offer expires and ensure that all participants enjoy the same opportunity to take into account all possible relevant factors for the same period of time. Essential tender conditions such as the period of validity for tenders must therefore be unambiguous, and it must not be subject to interpretation. Then paragraph 29, a further objection. The Commission argues it would be unacceptable, for reasons of transparency, etc., for there to be a dialogue. In particular, it is improper for the Commission to contact a particular tenderer so that the latter could set its tender in order, except in respect to certain specific issues where this is expressly permitted. Indeed, such an approach would fly in the face of a system which is based on the fundamental principle of equality of treatment between all tenderers. And then they say, well, what about workload? This would impose a heavy workload, because in 2001 it dealt with some 240 contracts. And over the page, they make an argument, a sort of slippery slope or floodgates argument. In the present case, 5 other tenderers were excluded following a variety of errors, and that to accept the arguments of the applicant would at the very least call into question the situation of those other tenderers. More generally, it would oblige the Commission to justify why it followed its own rules whenever a decision it had taken in accordance with those rules were queried. And then finally, paragraph 32, its final argument, it reiterates the alleged existence of a suspicion as regards the offer's validity is irrelevant in view of the clarity with which the time limit issue was set out in the tender and the strictness of the rules governing tender procedures. Now you'll see why I've gone through all of those, because a lot of these arguments are really wide-ranging and could have led to a scenario where the judge said, the European Court said, this is a situation where those justify no obligation arising. Indeed, the Commission was really saying, no, wouldn't even be lawful. It would have been unlawful negotiation. These are strict fundamental conditions. Could I ask you to note on page 64, we're now in the European Court's decision, paragraph 38, the Court makes the point, the Commission has a discretion to exercise to seek clarification. And it would be contrary to the principle of equality for an evaluation committee to enjoy an unfettered discretion to seek or not seek clarification, regardless of objective considerations and free from judicial supervision. So this is another aspect of equal treatment, which is where you have, as the DWP had here, a clear express power to seek clarification, then that needs to be subject to judicial supervision. And then paragraph 39, the Court recalls the principle of proportionality, that measures adopted by the community institutions do not exceed the limits of what is appropriate and necessary. And we rely on this in particular, where there is a choice between several appropriate measures, recourse must be had to the least onerous. In paragraph 41, the Court makes the point, if we just have a look 3 lines down, the Court considers the evaluation committee should have realised the applicant was probably, doesn't need to be certain, probably not intending to make its tender subject to a different period. And then it looks in context, addresses that in context. Looked at realistically, probable.
There is a slight wrinkle on Tideland, which is that the principle of good administration
Yes.
from Freedman J, which is an EU institution principle, which is not necessarily imported wholesale into the regulations here.
Yes.
I'm not saying that dilutes the force of the passages you've directed us to. I'm just saying, making it clear as a general caveat.
Yes, and we would say, absolutely. I think the courts here have been resistant to any general principle of good administration being imported. But what we would say, of course, is that we have instead that any public law power, such as the discretion here to either waive requirements or to seek clarification, is subject to rationality.
I understand, and I'm not saying it dilutes the
No.
passages that you've drawn to our attention. It's just if you look on in 42, the consequence to the passage you've just drawn our attention to does pray and aid the principle of good administration.
Yes, but we would say it hasn't been diluted precisely because if one reads on to 43 in addition as regards to principle of proportionality. So it's really two foundation stones. This isn't that 42 is what's propping up the house, as it were. We've got 43, which is as regards the principle of proportionality specifically. The court finds that in the present case, the evaluation committee, faced with the applicant's ambiguous tender, had a choice between two courses of action, either of which would have produced the legal certainty referred to at paragraph 34 above, namely, to reject the tender outright or to seek clarification from the applicant. And it goes on to say, given the likelihood that the tender was indeed intended to remain valid, and the fact that the applicant would have been obliged to provide within 24 hours any clarification sought, so the tender procedure as a whole would have suffered only minimal disruption and delay, the court holds the evaluation committee's decision to reject the tender without seeking clarification of its intended period of validity was clearly disproportionate and thus vitiated by a manifest error of assessment. We say both those principles would apply here. Then I was going to go to Antwerp's next, which is behind the next tab, tab 5. And just highlight a few points. So could we start on page 72, paragraph 5? Because it's important to bear in mind the clarity of the rule here. So paragraph 5, the applicant took part in a procedure, as did Company C and two other undertakings. They were sent the contract documents, the administrative annex to which states at point 25, as the court later refers to point 25, that the contract is to be awarded to the cheapest tender. That was apparently the only criterion, and that failure to state all the prices required will result in exclusion. And that also applies where alterations are made. So one can see there a very, very clear rule. Failure to state all the prices required will result in exclusion. Now, there was no dispute that certain prices had in fact been omitted. There were blank cells. And one can see that from paragraph 7. Second line, the report states that Company C has given a unit price for item 030915B, but omitted to include it. Company C also omitted to give a unit price for E9. No omissions were found in the tender of the applicant, and that Company C and other undertakings all omitted to give prices for some reason, for some items, and for that reason their tenders have been considered non-conforming, and therefore the only conforming offer was submitted by the applicant. So on the face of it, they had literally omitted prices and were in clear breach of the very clear rule. Then Company C was rejected. It asked for explanations, it was told why, and you can see in paragraph 10, it said, well, there's no problem because the missing prices can be deduced from other items.
That's to say by paragraph 10, the focus is all on item E926, for which they omitted to give a unit price.
Yes.
Yeah.
So it then said, well, in that case, you can have the contract, and then it was challenged by the disappointed bidder. And again, if we could just look at some of the arguments made by the disgruntled bidder, that's on page 74. Sorry, no, that's in relation to another, that's in relation to transparency. It's actually page 76, where we can see the arguments on the substance. So in paragraph 38, the disgruntled bidder relies on the fact that there was, under point 25, a single award criteria in the price, and that all the prices had to be stated, otherwise the tender will be excluded. 39, this is the argument of the disgruntled bidder. Under a strict procedure, negotiation between the contracting authority and tenders is not possible, nor may tenders amend or supplement their tenders after submitting them. Consequently, a tender which does not comply with the conditions laid down in the contract documents must perforce be rejected. Otherwise, the power to ask for clarification concerning tenders would be in breach of the principle of non-discrimination as between tenderers and the obligation of transparency, which applies in the present case by virtue of the contract documents. And then paragraph 40, it relies on Commission in Denmark, which we don't need to go to, that's in the bundle, but that's about substantive non-compliance. Paragraph 41, it's also apparent from the evaluation reports that contrary to the clear instructions in point 25, the cost estimation summary was not completed in full since no price was quoted, and that's why it was rejected. And paragraph 42, you see how, again, it encapsulates its case. This is about the third line down. Contrary to the opinion of the Commission Legal Service, the letter from Company C cannot be regarded as clarification, since it does not relate to an element which was already included in that undertaking's tender, but seeks rather to supplement that tender by inserting a price which did not appear there. In reality, the Commission allowed Company C to amend the tender which it had submitted, even though such amendment is prohibited under the restricted procedure followed in the present case. And then it goes further in paragraph 43 and says that can't be a clerical error. If you have failed to quote for a price, can't be regarded as a clerical error, even if the missing price can be deduced. Could I ask you to also note, your Lordship to note over the page of paragraph 46, the applicant actually disputed what the price might be. It says the applicant further submits that although it's indeed correct, the wording of two items was identical, the fact remains that the price quoted by Company C for the second of those items cannot be deduced from the price quoted for the first. The same wording appears in other items in the summary, and it sets out other items, and the applicant quoted different prices for each of those items. Since it was not possible to deduce the price bid by Company C for item 9.26, its tender should have been rejected as incomplete. So then we come to the findings of the court. And what I'd like to highlight, first of all, is paragraph 50, which recognises the difficulty for contracting authorities. They can't be omniscient. They can't predict everything. Although a contracting authority is required to draft the conditions relating to a call for tenders clearly and with precision, it's not required to make advance provision for all the situations, however rare, which could in practice arise. And then 51, and this is important, they look at the condition laid in the contract documents must be interpreted in the light of its subject matter, broad logic and wording. Where there is doubt, the contracting authority concerned may gauge the applicability of such a condition by conducting an examination of each individual case, taking into account of all the relevant factors. And I'm going to be relying, when it comes to my submissions, on that need to look at the broad logic of the rule. Then if we go over the page, paragraph 54, we've seen there's the discretion, there's the power to seek clarification.
I thought that the rule depended on what the Arwind tenderer thought the rule meant.
Yes, but we'll see. You also look at the purpose of the rule, and the court's going to come on to do that, to say, is there effectively damage to the purpose of the rule here?
Yeah, I mean, in health,
Intelligence.
yeah, it talks about it being a question of what the Arwind tenderer thought, and says something to the effect that there's an objective element to that.
Yes, my lord.
But I'm not sure about broad logic.
Well, I think the point here is when looking at the application of the rule, it's also got to look at what purpose is it serving.
Yeah, I get that.
Yeah, so that's what I'm relying on it for. So if one looks at what's the mischief here, and in this particular case, what is the mischief of the rule that you can't exceed the framework maximum? It's because contractually you're not permitted to. It's not a rule which is seeking a sort of gotcha rule that if you make a single mistake, your tender's out.
Okay. Yeah, sorry, so that's 51. Which one were you going to next?
Come on to, I'll link that in a moment to the reasoning of the court, but in paragraph 54, the court addresses that there is a power under the regulation to contact tenderers for clarification, but it follows that provision cannot be interpreted imposing, in the exceptional limited circumstances which it identifies, a duty. 55, it can be otherwise only if by virtue of the general principles of law that power has evolved into an obligation. And paragraph 56 is where we're dealing with the discretion actually being an obligation. That is the position inter alia. Not categories aren't closed. That is the position inter alia, where a tender has been drafted in ambiguous terms, and the circumstance of the case of which the Commission is aware suggests that the ambiguity probably has a simple explanation and is capable of being easily resolved. In principle, it would be contrary to the requirements of sound administration for the Commission to reject the tender in such circumstances without exercising its power to seek clarification, and it would be contrary to the principle of equal treatment to accept that in such circumstances the Commission enjoys an unfettered discretion. And then 56, it also refers to the principle of proportionality.
57.
Sorry, 57. I apologise. The principle of proportionality requires that measures do not exceed the limits of what is appropriate and necessary in order to attain the objectives legitimately pursued, it being understood that where there is a choice between several appropriate measures, recourse must be had to the least onerous, and that the disadvantages caused must not be disproportionate to the aims pursued. And then again we have a point of principle. That principle requires that when the contracting authority is faced with an ambiguous tender, and a request for clarification would be capable of ensuring legal certainty in the same way as the immediate rejection of that tender, the contracting authority must seek clarification from the tenderer concerned, rather not purely and simply to reject the tender. Then paragraph 58, there are safeguards here. One can see that where a tender, this is the end of paragraph 58, where the tender is ambiguous and you're not in a position to establish quickly and efficiently what it actually means, there's no choice but to reject. And then 59, also, having asked, the contracting authority should then assess the replies. It's not, once it asks, it's not bound to accept them. It then can assess whether the explanation goes beyond clarification and modifies the substantive terms of the tender. So paragraph 60 then applies these to what was before it. It's got point 25, which says that you can't miss out any information. And what it's determining is whether, as the Commission submits, having regard to point 25, that the tender cannot be rejected where there is a simple explanation for the clerical omission in question, and the missing price can be deduced easily and with certainty from the bid price for another item in that summary. That was how the Commission put its case, but we'll see the Court puts it rather wider than that. Then 61, the Court looks at the broad logic of point 25. The condition laid down in point 25 is intended to provide the contracting authority with a detailed explanation regarding the way in which the overall price bid for the contract by each tender is broken down into individual prices for the various operations. Over the page 62. Must also be held that the obligation on each tenderer to quote a price for all the items in the cost estimation summary is intended to enable the Commission easily to verify the precise nature of the overall price and determine whether it's normal. And lastly, that obligation is intended to facilitate an adaptation of the overall price in the event that additional work proves necessary after the contract has been awarded. So it's looking at the purpose of the rule. And they say in paragraph 63, as regards that condition of point 25, attainment of the above objectives is in no way affected by the Commission's interpretation of that provision, to the effect that a tender is not incomplete and need not be rejected if the missing price for a particular item can be deduced with certainty, or, and this is where it goes further than what the Commission was arguing, or at the very least, after obtaining clarification of the terms of that tender from the tenderer who submitted it. So this is obviously all looking at the nature of the rule as well, point 25, which explicitly said you can't miss anything out. 64, as the Commission states in the last
Hang on,
situation.
I just need to get my head around the syntax of 63. So this is saying that the above objectives aren't affected by the Commission's interpretation of that provision, to the effect that a tender is not incomplete and need not be rejected if the missing item can be deduced with certainty, or at the very least after obtaining clarification. What, that it can be deduced with certainty after obtaining clarification?
Yes, well, it doesn't. What they're saying is, if you look at the purpose of the rule, it's not affected if, although there is, on the face of it, a missing item, you can either work that out from elsewhere, or you can go and check with the tenderer, is this what you meant? That item E6 is the same as E9.
Is affected the wrong word? Should it be an E?
No, I think it's that.
So the Commission's interpretation doesn't affect that provision.
Yes. It doesn't run counter to the purpose. I think that's the way I'd put it. It doesn't run counter to the purpose, the broad logic of the rule.
Okay.
And the way that I interpret it is, if one contrasts it with the Commission and Denmark case, which I haven't gone to, but that one you might recall is where there was a strict rule against variance, and also a rule that if you're effectively an allocation of risk, the tenderer had to agree to an allocation risk. Now, if you interpreted that so as to say, well, another tenderer doesn't need to comply with that, then that would obviously run counter to the logic of the rule itself. So when one's looking at the purpose of the rule and its interpretation, and whether clarification is permitted, it's relevant to look at the nature of the rule and what it's serving. Another way we'd put it is look at the mischief.
Well, a better way is in 64, isn't it?
Yes.
It's just explaining the terms of the tender to make it clear that a price bid for a particular item should be understood as having been bid for all the other like items, against which in this case there was no price.
Yeah. But it's saying, well, it's can't say, in paragraph 65 as well, a purely literal and strict interpretation of the condition, as proposed by the applicant, would lead to the rejection of economically advantageous tenders because of clerical errors which are obvious and insignificant, the course of action which, as the Commission rightly points out, cannot in the long run be reconciled with the principle of economy. So one could either say there's a strict rule, empty cell tough, or one can say, well, that is not breached, it's still compliant if either it can be deduced with certainty, or at the very least after seeking clarification.
Mm-hmm.
So it's not that it needs to be apparent on the face of the tender. And of course that was all, and I do emphasise this, the very rule itself prohibited explicitly an empty cell on its literal terms.
In 64, if it hadn't been possible to deduce from other parts of the tender what the price should have been inserted in that particular cell, that would have been a problem?
Well, that's potentially the implication of 64. But it's odd, isn't it? Because it does say, after obtaining clarification of the terms of the tender from the tenderer who submitted it. So it might be, well, it says, it's simply a matter of explaining the terms of the tender in order to make it clear what was intended.
Might the slightly constrained way that it's being addressed by the court there be explained by the particular regulation in issue in that case, which looks rather more tightly drafted than the regulations concerning this case.
We say exactly that.
I'm looking at page 70 and 71, which I think is the Article 148, subparagraph 3, which is the critical regulation, I think. So the constraint there is the contact may not lead to any alteration of the terms of the tender.
Yes, sorry, I thought you were talking about the terms of point 25. But
No, I'm talking about the regulation that was
yes.
that was governing this particular case.
Yes. It's difficult, that, isn't it? Because strictly any correction of an error is an alteration of the terms, literally.
Yeah. But the question I'm asking is, does that create a difference between that case and our case, where regulation 56.4 is, on the face of it, in broader terms?
Yes, that's one of the points. We'd also say, of course, we say this is part of the problem below with respect to the judge, is elevating examples into rules. And we say the condition for correction...
Sorry, elevating...
examples into rules. Because we say what postdates Thailand, what postdates Antwerp, is Arcus, which sets out comprehensively the conditions in which corrections and clarifications are permitted, with the benefit of all this case law behind it. And we know those conditions, and that's where we say the judge erred by going beyond those and imposing new conditions.
Mm-hmm.
But the regulations in the Antwerp case expressly deal with clerical errors, don't they, under contact with the bidder?
Yes, and we also have that though enshrined in Arcus, where it says even an error, an obvious error, vitiating the tender. You don't need a specific power, but in any event, we've got Regulation 56 here, which is broad enough. Now, I'd like a final case to go to on correctional clarification is the Siemens case, which is tab 27, so that's in bundle 2. Oh, sorry, no, bundle 3. Sorry, I apologize.
Yeah.
And I go to this not so much for the legal principles, because they're dealt with quite shortly and uncontroversial, but for an illustration of the practical real-world impact of these conditions and the practical real-world problems of extending the conditions in the way that the judge did below. And this is behind tab 27, and if one goes over the page to 1016, one can see, this is all part of the head note. I'd ask you to see second paragraph down by the first hole punch, that this was, the value of the proposed contract was 2.75 billion.
Yeah.
Now, as one can imagine, in a complex, high-value procurement, there can be hundreds of price components. And if one goes to page 1089, I'm going to just touch upon, this is a huge challenge which took every point possible. So these are dealt with quite shortly and concisely, understandably, by Mrs. Justice O'Farrell. But at the bottom of page 1089, you can see the allegation. So Siemens was the unsuccessful bidder. And it alleges that HS2, the contracting authority, acted unlawfully in allowing the JV, that's the winning tenderer, to supplement its bid by providing tables to reflect the daily unit service charge. 534, the financial pro forma required tenderers to enter the daily maintenance charge for 7 bands. I won't go into the details. 535 over the page, you can see Mr. Warren's evidence, that's the contracting authority, was that he picked up an apparent inconsistency in the tenders between the figures for the daily unit charge in the above tables. So, he raised a clarification question with Siemens, and Siemens explained that its figures were not intended to match. So, it hadn't made a mistake. But then he asked the winning bidder, 536. He raised a clarification on this issue with the JV, and in its response, the JV acknowledged it had made an error in the commercial proposal. It had wrongly included the heavy maintenance charge within the daily unit charge, and the JV was permitted to correct this error by providing a replacement table together with revised tables. 537. As explained by Mr. Warren, the result of the JV's error was to overstate the daily unit charge for the purpose of the Appendix M. Appendix M was the basis for the contractual price, and if uncorrected, the overstatement would have resulted in a significant overpayment under the contract. However, Appendix M was not used in the WLVM to calculate the assessed price. The financial pro forma which was used and the assessed price had to be populated correctly. Therefore, allowing the JV to correct its error was within HS2's discretion and did not have any impact on the evaluation. That's the first example. We say direct analogy with 2 of the 3 cells here, where didn't form part of the evaluation. No problem whatsoever in allowing that error to be corrected. Then we come on to the next, paragraph 539. Next, there was an error, 539. It was permitted to correct an inconsistency in its bid as to the timing of the option units and the milestones. 540, Mr. Warren identified an inconsistency in the bid relating to the dates. He permitted the JV to correct the inconsistency by providing new dates. 541, the revised dates had no impact on the prices for each option unit, the milestone payments or service value, charges value in the bid, but they did affect the NPV figures in the financial pro forma and did result in a modest adjustment to the JV's assessed price, a few £100,000. 542. This request for clarification and correction was within HS2's discretion under section 6.6.3 of the IFT because the dates originally submitted were obviously erroneous and the change to the assessed price was not substantial or material to the outcome. I could ask you to note 3 points in relation to this. 1, these examples amounted to amendments to the bid. They clearly changed the bid. But that did not matter because they did not amount to a new tender. So the test is not, is the bid changed? And we know that from ARCUS, and that test should not be tightened so it becomes a restrictive noose. It is there fundamentally a new tender, not a change to the tender? The second point is that there's no suggestion here, quite the opposite, that the contracting authority could have worked out what the corrected prices were. They had to ask. They weren't available on the face of the bid. And the third point, of course, is that Siemens could complain that it had not made errors.
Sorry, Siemens could
Complain, as any disgruntled bidder can, where a correction of an error is permitted. Well, this is unfair because I put in a correct bid. That's not enough to make it a breach of equal treatment or transparency. We've seen ARCUS. Does it actually lead to a disadvantage or a risk of a disadvantage in light of the outcome? And that's why Justice O'Farrell was able to say here, and we say rationally and consistently with the touchstone of procurement, changing these prices had no effect on healthy and effective competition.
The ITT in the Siemens case, which is higher up in paragraph, I think 514.
Yes.
HS2 specify with a bit more detail the circumstances in which they will be able, under the terms of the competition, to seek clarification, don't they?
Yes, and of course, again, I'm not trying to elevate an example into a rule. Of course, everything will depend on the terms, the precise terms of the contractual documents. But clearly, what it couldn't do contractually, if it were really in breach of equal treatment, to say you cannot amend a price, the price has to be deduced. You can't change the price at all, can't touch the price, it's sacrosanct. You can't contract out of that by putting an ITT, we're going to let you amend the price. And that's why we say the judge went too far when adopting the approach of did it change the bid, did it insert a price, which the contractual authority could not have known. And we say that Siemens illustrates that when looking at these rules, one has to be very careful about expanding the conditions beyond how Arcus has formulated them because of the real-world repercussions for, in particular, very complex procurements.
Yeah.
Now, the third and final topic, which I can deal with briefly, because we say it's of limited relevance to this case, is waiver of terms that are said to apply without exception. And this is conceptually distinct from clarification or correction of errors. And we can see that from going to Leadbitter briefly. Now,
Leadbitter is another case about failing to do it in time.
Exactly, deadlines. And we do say, I know there have been some judges who've expressed a view, what's the difference between a deadline and changing something after the deadline? And we say, well, there is a difference. It's been dealt with in Arcus. They're not elided. Sorry, it's Bundle 1.
Yeah, Bundle 1, tab 9.
Thank you.
Mr. Justice Richards, as he then was.
Now, this is a deadlines case, and we say, just as a preface to this, it is commonplace. Everyone in this room, whether a lawyer or not, understands the importance of deadlines and the inability in many situations to extend them.
I permit myself a wry smile in terms of some lawyers' compliance with deadlines.
Well, but if I could say deadlines, one understands whether it's a tax return, whether it's a limitation period, whether it's buying your lottery ticket in time, people understand a deadline is a deadline. And that is a simple point that's made in Leadbitter. And that's why we say it's problematic to try to read across Leadbitter and the potential difficulty of saying, well, wait a minute, I exceeded the deadline only by a minute. That does not tell you anything about other circumstances, necessarily in proportionality. So one can't necessarily read across. But if we look in the rules here, could we pick it up at page 133? So, paragraph 14, one can see the last sentence, the return deadline would be strictly 12 noon. 15, that was reiterated, and could ask you to note the explicit statement at the bottom by G, an incomplete set of documents will mean your tender is invalid. Over the page, paragraph 17, the deadline was stated to be fixed and firm. And paragraph 18 could ask you to note the bold, just above paragraph 19. If your tender is not fully submitted before the closing date and time, it will not be accepted. Now, paragraph 19 shows a different aspect of the ITT, which is about correction of errors, which didn't come up because that wasn't the issue. But if one looks at paragraph 19, it says section B 2.25 provided as follows for the correction of errors. Should a material and genuine error be discovered in the tenderer's submission during the evaluation period by the tender evaluation team, the tenderer will be given the opportunity of confirming their offer or of amending it to correct the error. And that raises rather different. That's why I say conceptually that is distinct correction and clarification is distinct from waiver of strict conditions, which are stated to apply without exception. And this is a point that the judge himself goes on to make. And this is at paragraph 56 on page 147. Now, we illustrate that point here by saying, imagine if Optima had ticked no in the questionnaire. Said, we don't accept your terms because there's one term we don't like, which is that our prices are capped by the framework maximums, and we'd like to exceed it for OH58, please, because market conditions have changed, our costs have increased. Now, that would, if the DWP had purported to accept that, that would be a waiver of a condition, which is stated as applying without exception, and would be a departure from the terms of the procurement process and an exceptional course. We agree with all of that. But that's obviously very different from the case law on correction or clarification of errors. So, my lords, those are the headline points on the legal principles, and I'm now going to turn to where we say the judge went wrong. And I'd be grateful if for this, your lordships could have in front of you the decision, which is a core bundle, tab 5, starting at page 42.
So, is this a freestanding section dealing with the judgment? Or
no,
is this,
I'm going to go straight into where we say the judge went wrong, unless...
Well, by reference to the ground?
Yes.
Right,
Yeah.
fine, sorry. Okay. Yeah, well, that's good. So,
And-
we ground one.
Exactly, but bearing in mind your lordship's observations on the application for permission to appeal, we've clustered this, as you'll have seen from my skeleton argument, into effectively two issues. The
Yes,
first issue being the
but
clarity
your skeleton explains that, but also quite rightly sets out what you say about each of the individual grounds. Take your own course. I mean, I think that ground two, that is the essential point, but there are different strands to it as your individual grounds
Yes.
point out. I mean, the only separate point is ground one, it seems to me.
Exactly, but as I'll come on to see, even that is linked to ground two. Because
Well, we'll come to that because when you've dealt with ground one, we do need to address where that goes, because the exam paper question drafted by the parties for the judge does not make that clear. I don't like exam papers set for judges by parties, because judges always say, if the answer to question one is yes, go to question two. If the answer to question no, go to question three. Council don't seem to like that. They like to keep their options open. And I'm afraid that doesn't always lead to clarity, and that may have more than just a passing relevance to this case and the judge's approach. So we do need to look at that quite carefully. But let's have your submissions on ground one first, and then we see where you say, if you're right about ground one, that goes.
Yep. Thank you, Laura. So, can I just encapsulate that the DWP's case, we can see if one just keeps in the same bundle, behind tab 13, see in their skeleton for this court, at page 213, how they put their case, and it's a neat encapsulation, so I'm going to rely on it. They say, paragraph 4, bottom of page 213,
Yeah.
as Mr. Justice Freedman correctly found, the decision was lawful. Clause 2.2 of Attachment 1 of the ITT provided a clear rule of mandatory exclusion where a supplier bid priced in excess of their maximum framework prices. And as regards its discretionary right to exclude Optima for non-compliance, DWP exercised that discretion lawfully. By contrast, it would have been unlawful to allow Optima to correct its non-compliances. That would have amounted to a change to its bid, would have been unfair to PAM, who had submitted a compliant bid, and in breach of the principle of equal treatment. So their position is it would have been unlawful. So the first issue was whether it was required by a clear rule of mandatory exclusion. And the phrase, the clause in question is behind 161, or at page 161 behind tab 10.
Yeah.
And the significance of this is that DWP argued, and the judge accepted, that DWP had no choice but to exclude on the basis of this. And if we look at it, I've already taken you to other examples where we say where a failure led to disqualification, it's made crystal clear. If we have a look at this, the maximum contract value is governed by the framework. Any bids for any service line submitted to the framework by invited bidders in excess of this will be discounted. Now, this clause lacks clarity in several respects. So first of all, it uses the word discounted, and on its normal and ordinary meaning, that can either mean to reduce the price, or it can mean disregarded. And of course, the point here is that what we have is a cap. So we'll say discounted makes sense here, a bit like in excess of a word count, the words above the limit are disregarded. So whether one uses discounted as reduced in price or disregarded, it can mean insofar as they are in excess of the framework agreement. Also, it refers to any bids for any service line submitted to the framework. And if one looks at the explanation of the bids in attachment 2, could I ask you, your Lordship, to look at page 172?
Yeah.
Here one can see, if one 1.4.3, prices offered will be evaluated against the range of prices submitted by all prudential providers for that item. And then it looks, if you look at the examples, it's provider A submitted price 1,000, maximum score available is 100, and they have the lowest price, they get 100. So this, the wording of this suggests, when it looks at any bids for any service line, that any discounting or disregard might be applying at the level of the item. You don't get a score for that item, you get 0. Now, as it turned out, DWP departed from that. It's not actually what they did. They looked at it at the maximum value. They didn't do it item by item. We say that simply compounds the lack of clarity of these instructions. The other point to note is that this refers to the first line, the maximum contract value is governed by the CCS framework. And it says any bids for any service line by invited bidders in excess of this will be discounted. Now, Optima's because it reduced all of its prices, the maximum value was well below what it would have been had it been under the framework agreement. Now, as the defendant's internal documents acknowledged, and I of course accept that this is not determinative, the same way that evidence from an individual bidder isn't, but the defendant's internal documents acknowledged that the wording of that clause was ambiguous and open to interpretation, and that is in the supplementary bundle, second supplementary bundle, at page 267, which is behind tab 33. If we could go to that briefly.
Yeah.
Could I ask your lordships just to read that page?
Yeah, by the first hole punch, giving
Yes.
rise to some ambiguity which may be open to interpretation.
Yes. And then if we go to, one can have a look, for example, at the third bullet point. Discounting the prices that are over the framework price caps back to the framework price caps. And the only reason they reject that, or that we can see, this is largely privileged, there's no process identified for this in any documentation.
Well, we have to go on simply what we've got.
I know.
The respondents have chosen to blank out much of this page. It shows how I haven't sat in the TCC for a long time, because my views about that are well known. But they have, that's their right, but that's all we can go on for that third bullet point.
Exactly. But we can see what they say is, well, that can't be right, they say.
Because you say the answer to that is, well, there's a power to clarify.
One, there's a power to clarify. And what process is needed? If you're going to disregard words above a word count, you don't need a special process for that. You say you're going to disregard words above a word count, you disregard them. If you're going to discount prices back to a framework price, discount them. You've got the framework prices, you're known. And to this extent, it's not a new price, it's a known price. It's the framework agreement price, and you can say, did you mean to exceed it? No, you didn't. Well, we're going to discount it. And we know that that was possible because I've already taken you this morning to the document where they did exactly that, and they discount it, and that's where they get the 0.002% from. That was the exercise they did. It's readily available to them. They actually did it for other purposes. Now, the other point about that is that, of course, it does still impose a sanction for the error because the bidder has lost the opportunity to put in a more competitive price. You're not giving them, as the contracting authority, any advantage. They never intended to exceed the maximum. And what you are permitting them to do is therefore put in the highest possible price they could have done, the least competitive price. And the other point, the final point I wanted to make on this, is that one can also ask discounting for what? Because the contracting authority, or DWP here, says, well, we needed a price because we need to contractualise it. And you'll recall that's exactly where in Siemens, Mrs. Justice O'Farrell's first example is an analogy. There was a missing or a wrong price, it wasn't evaluated, but it needed to be corrected for the purpose of the contract. So here another option would actually have been to evaluate on the basis of the wrong high price, but to contract on the basis of the contractual terms and conditions, which Optima had already agreed applied, and had already said the prices were subject to. So then let's turn to the arguments and how those were addressed in the decision. We put away that supplementary bundle.
Yeah.
A price lower than the maximum, going back to your discounting point, would have been to the benefit of the DWP, wouldn't it?
It would, exactly.
Yeah.
And that's why some contracting authorities permit a different price to be put in.
Yeah.
Because
so your solution to discount the maximum is not most in the public interest.
no, but it would eliminate the possibility of any competitive advantage.
Yeah, I see that, but it's most in favour of the public interest would be to seek clarification.
Yes.
Yeah.
And of course, we would say there, the fact that if you sought clarification, it was a new price, is not of itself unlawful because we've got the example. It depends on the facts. We've got Siemens, where they put in a new price, but it was not material. It didn't affect the outcome.
Well, it also achieves contractual certainty, doesn't it?
Yes. So if we then go to page 123, paragraph 1.
Paragraph 123.
No, sorry, those were our submissions below. Let me just pick it up at the discussion at page 85.
Are we in the judgment?
We are, sorry, in the judgment behind tab 5.
Page 85.
So paragraphs 132 and 133 are introductory, and then we see in the event.
Well, if it
Yep.
saves time, we've read your submissions about this and we see what the judge said. So if there's any particular, I don't think we need to work through it paragraph by paragraph, and I don't think there's the time. So if you want to make particular points on this, on any particular part of the judgment, I mean, you make the point in the submissions that the judge is very clear about what about the warnings that you can't exceed the framework maximum price, and you say he's not so clear on why that should have led to exclusion. I think I'm paraphrasing your submissions, but I think that's what you said.
Yes, so exactly. 134 onwards, we get repeatedly, look, here's what the rule was. We say that's akin to saying, here's the word limit, here's the word limit, here's the word limit. It doesn't deal with the consequences of that. Then paragraph 139, he starts dealing with the possibility of disqualification. I reject the notion that an R-wind in the circumstances did not know the consequence might be disqualification. And then the crux of the mandatory is dealt with in paragraphs 140 and 141 is really where the judge below deals with the mandatory, the argument from DWP that they could not do anything that's mandatory. Although there was an internal note about an ambiguity in context, it was not ambiguous, but it only sensibly had the meaning about it being excluded. The reasons for that were set out in the summary of DWP submissions at paragraph 130 above. So let's just have a quick look at those reasons that he's relying on. And here is their submission that he accepted. In the context, the reference to any bids will be discounted must mean the entire bid would be disqualified, bearing in mind the following. 1. The context of the other references to the requirement not to exceed the framework maximum prices and the need to comply with the rules in the ITT, failing which there was a right to exclude the bid. Well, that's not dealing with 2.2, that's dealing with separately the discretionary right to disqualify non-compliant bids. 2 is again dealing with the possibility of excluding. This isn't dealing with mandatory. This is no argument that this is mandatory. 3, there was no suggestion in the ITT that DWP would adjust the prices bidding for the relevant individual line item. But that again doesn't address it because it depends on how you're just interpreting the word discount. And then 4, if discounted meant reduced, there was nothing to suggest the extent of the discount. There was nothing to show it meant a specific price, which the bidder had in mind between nothing and the maximum sum. But of course we would say where there's a cap, then one plausible meaning is that you do discount the cap. Or it'd be discounted through a process of clarification. And what these arguments don't address is the multiple possible meanings and the fact that the ITT could have said in clear terms that any error meant disqualification. They could have done that, and it did not. And we say it was incumbent upon the ITT, if that's what DWP meant, not just that you substantively do not accept the terms, but if there's any error, it necessarily follows there must be disqualification, then it was incumbent upon them to make that draconian consequence clear, particularly as we say, if one looks at what is the broad logic of that rule, it is very difficult to discern. A deliberate refusal to accept the terms and conditions of the framework, well, that makes sense. But a refusal to permit even clarification or correction of a spreadsheet, very difficult to see what on earth the logic of that would be. And you'll have seen the point that we make in this in relation to the skeleton argument is that your lordships have seen that the bidders repeatedly didn't fill in the spreadsheet correctly. Now, if this was a clear rule of mandatory exclusion that either shows extraordinary self-sabotage by the tenderers or that it was very difficult to do, but it doesn't indicate or support an argument that this was clear, everyone knew what to do, and knew that there would be disqualification if they failed. So that's paragraph 130. And importantly, 141, he goes on to say, in context, it makes no sense that there would be a discount meaning reduction when it would not have been possible to define what the reduction ought to have been between naught and the amount of the maximum sum. Well, two answers to that are, first, it could be dealt with through clarification. And secondly, you could discount to the maximum, which is known, and which Optima had accepted.
That in itself is an ambiguity anyway, isn't it? It's really relying on an ambiguity in order to reject it as being ambiguous.
Yes. And he goes on to say it was not a neat solution to discount the bid to the maximum. That is not what it said. Well, that's circular. The witnesses were at one in saying there was no way without more that Optima could understand whether the discount was to be the maximum line sum or to a lesser amount. In those circumstances, and for the reasons submitted by DWP, which I think can only be paragraph 130, the natural meaning of the word discounted was that the bid as a whole would be disqualified or excluded. And then paragraph 142, if contrary to the foregoing there was a potential ambiguity about the meaning of the word discounted, there was, on looking at the process as a whole, no ambiguity. And here's where he accepts the submissions of the defendants. Could I ask you to read those at the bottom of 86? Now, he doesn't explain, if there is an evidential basis for that, what it was. That seems to just be an inference. And an understanding, we say, with respect, an erroneous understanding, that they couldn't be contractualised. They could through the process of clarification. And there was an explicit power to seek clarification. And the suggestion here is that there was only really one course available. There weren't other courses available, and we say there were other courses available, and that's the fundamental problem here, is assuming that it could only mean one thing because everything else was unlawful. Now, I see the time. Would your lordships like to raise me in relation to, if you're with me on this first point, the point that your Lord Justice was making earlier about where does that lead us?
Yes. Where does it lead us?
We say what it leads.
I mean, we may be completely against you, we may be for you, who knows?
No, absolutely.
But we need to know what our options are, as I think the judge possibly needed to know. Assume you're right. Have I got this right? You then say it's a question of discretion and it's Tide Land Antwerp set out.
Yes, we say it's a matter of discretion.
I appreciate you have separate arguments that say that they exercised it unlawfully, they misdirected themselves in law, all of that. But it's all under the general umbrella of ground to the discretion,
yes.
the clarification, proportionality,
That's
all
right.
of that.
That's right.
So that's your case if you're right on the mandatory exclusion.
Yeah.
If you were wrong, what do you say are the consequences, and what in particular were the consequences did the judge understand? I mean, I'm looking at page 199. Can I tell you what just before we break, can I tell you, this is speaking entirely for myself, my concern about this. Page 199 are the issues.
So
And
199 of the...
199 of the core bundle, your
Yes.
skeleton.
Yes.
The issues that the judge had to decide.
Yeah.
Okay? issue 1, which is ground 1, did the tender documentation clearly and transparently set out the consequence of exceeding the framework pricing schedule in particular? And then the points about mandatory or not, effectively. Okay? Then issue 2, with the sub-issues, if the tender documents were clear and DWP therefore had a discretion. Those two things seem to me to be, from issue 1, trying to tease out the answer to my question. If you're right, then what? If the documents were clear, that means if they clearly and transparently set out the consequence of exceeding the framework pricing schedule. You say they don't in terms of it being a mandatory exclusion clause. And so it's not clear what the judge thought. The judge found there was a mandatory exclusion. On one view, that was it. Yeah. He doesn't deal with the judgment like that, but on one view, that was it. And in Mr. Sutterwaller's skeleton argument, he makes that it's his case. There's a mandatory exclusion, and that's it. But do you accept that if you're wrong on issue 1, that's the end of the case?
No, for this reason, because even if there was a mandatory exclusion, there was also an explicit power to waive the requirements or to seek clarification.
Right. So what difference does issue 1 make?
If I am right, then maybe I'll think about this overnight, because I'm careful. I don't want to give you a formulation.
No, I'm not
I can
trying
see you writing down, my lord, and I'm going to be very careful.
I'm not trying to catch you out. I'm not trying to catch the parties out. I have made tart remarks about exam papers for judges. It's always much better to let the judge set his own exam questions, as BDW also demonstrates.
I couldn't possibly.
We'll sit again at 2 o'clock. Thank you very much.